Welcome to this UKLFI Charitable Trust webinar, Unravelling the ICJ Advisory Opinions. On the 19th of July this year, the judges of the International Court of Justice gave their advisory opinions in the case entitled Legal Consequences Arising from the Policies and Practices of Israel in the Occupied Palestinian Territory, including East Jerusalem. In addition to the main opinion, there were 14 separate opinions or declarations of the various judges. The court's Vice President, Sebutinde, dissented entirely from the main opinion. 3 other judges dissented from the most serious conclusions, namely that Israel's continued presence anywhere in the Gaza Strip, West Bank, or East Jerusalem is unlawful and must be ended by Israel as rapidly as possible. Many aspects of the majority opinion are ambiguous and difficult to reconcile with other opinions by the same judges in this case, let alone with other cases, and the factual circumstances of this one. As opposed to rulings, decisions, or judgments, these opinions are not binding. They are also mostly, unfortunately, given on the basis of information, including documents provided by the United Nations, which are of dubious accuracy. They were given without hearing arguments in support of Israel. However, opponents of Israel regard these opinions as putting wind in the sails of the BDS movement, and it is therefore prudent for us to seek to unravel them over the course of this webinar. I'm delighted to be joined for this purpose by Olivia Flasch, a legal consultant in public international law with a particular focus on armed conflicts and the use of force. She has worked with governments, UN agencies, and international organizations on a range of topics, including the verification of digital evidence in international criminal proceedings and the development of AI in the military domain. She's the author of numerous articles relating to Israel and international law in outlets such as the Jerusalem Post, EJL Talk, the Times of Israel, and the Lawfare blog, where she in fact wrote just before the advisory opinions were handed down in detail in that publication on the worrying factual underpinnings of the court's considerations in Facts Matter, a critical analysis of the ICJ's fact-finding approach. Ladies and gentlemen, please put your questions in relation to this topic into the Q&A facility in Zoom, and we will come on to those after our initial discussion about the opinion's status, its legal and factual basis, and its potential impact on the established and internationally endorsed peace process. Olivia, you are extremely welcome. I know you've been monitoring a lot of the academic discussion as to the status of the opinions and their potential legal impact. What is your assessment of how this development has been received?
Thank you, Natasha. Thank you for having me. Thank you, UKLFI, for having me on this webinar today. So exactly. I thought it would be a good thing to start this discussion off to just talk a little bit about what we mean when we say that the advisory opinion is not binding. And sort of, especially after this advisory opinion has come out, I've seen a lot of what I would say misinterpretations of that particular concept on the web in different webinars, but also just being reported online, where people are sort of saying that, yes, we know that advisory opinions are not binding, but the findings, the legal findings in an advisory opinion are binding. And so that has the effect of making the advisory opinion binding anyway. And so I just want to unpack that a little bit because I don't quite think that's right. Of course, if the legal findings were binding and it had the effect of making the whole advisory opinion binding, then there would be no point in calling it a non-binding advisory opinion. And that would become a little bit redundant. So I think, I mean, my understanding, and I think the understanding of most international lawyers, is that an advisory opinion is not binding, but they hold legal authority to the extent that they crystallize or declare kind of rules of international law. So they can be used a lot to kind of understand the scope of different international rules. And when we say crystallize rules of customary international law, It just means where you have a rule that's not written down, and of course, the court can then declare the scope of that and kind of give a bit more of an understanding of that type of rule. So, in that sense, they do have legal authority. And of course, the legal findings relating to specific facts can also have legal authority, but that legal authority will very much depend on the specific case and, in particular, on what those legal findings were based. And so, if you've got a situation that's very, very complex and where the factual findings, like you were saying, might be a little bit incorrect, they might have not taken into account every single perspective, they just might not be that great of a factual conclusion to base legal findings on, then of course that legal authority will be diminished. And we've seen that throughout kind of history with advisory opinions actually being perceived and received by states in different ways, depending on how they have kind of felt that the court went about the factual basis. So some advisory opinions where the factual basis has been not so complex, perhaps, or where there's been a pretty good delve into investigation into the relevant facts. Those advisory opinions might have been perceived with a bit more authority. Whereas when you have something like this, the advisory opinion issued in this case, and also the previous Wall advisory opinion issued by the court on similar facts 20 years ago, the perception and reception by states has been a little less authoritative in that sense.
It's perhaps in that context also appropriate to reflect on how appropriate the advisory opinion mechanism is in relation to the questions that were posed by the General Assembly for the court to opine on. And this is something which was raised by many in support of Israel, but also touched on by the dissenting judge Sebutinde. The nature of the issues here being bilateral, the absence of Israel participating in any way, the idea that the court would be essentially using what is supposed to be that mechanism, as you've described, of providing advice on general issues of international law, using that instead to, in a sense, resolve a bilateral dispute without having the parties before the court making their case. The political motivation by many of the states also in signing up to that resolution. I think that's something that you've referenced in your article subsequent to the advisory opinion, the number of states that don't have diplomatic or relations with Israel, or indeed recognize its existence. What do you think you've seen subsequent to the advisory opinion coming out in terms of the International Legal Academy assessing whether or not the court should have even opined on such a contentious and politically fraught issue?
Yeah, I mean, here I think you have a kind of clear split, which is very political because you've got, states that might be hostile towards Israel or might not have political relations or diplomatic relations with Israel, who, like you said, were all of the states that sponsored the resolution that in the General Assembly that actually asked the court to opine on this issue. Two-thirds of them don't have diplomatic relations with Israel, and several of them don't recognize Israel as a state. So those countries would obviously, for their own political reasons, feel that yes, this is the type of issue that the court should opine on. But then you've had quite a few states who said this in their written and oral arguments before the court as well. That this is not the place for this. This is not a bilateral dispute. There's no parties in advisory proceedings. I mean, I think that makes the whole thing actually the most difficult because how can you have a situation where there's no parties and then yet you've got people and countries saying when the advisory opinion came out that this is legally binding on Israel. But Israel wasn't a party to the proceedings and actually didn't participate at all. So yeah, I mean, it's just a very complicated issue. And the court tried to get around this by saying, well, this isn't a bilateral dispute that we're talking about here. We're talking generally about an issue that relates to international peace and security. But of course, in practice, that's not quite what we've seen afterwards.
And indeed, in the majority opinion itself, it's clearly making perceived judgments on the rights and legal interests pertaining to Israel. Criticized again, I think, for not applying the relevant international law to that process. One of the other aspects, Olivia, that you picked up, and I mentioned this in the introduction before the opinion was handed down, was in relation to the court's approach to fact finding. Now, you've mentioned the 2004 Wall advisory opinion. This is the other occasion in which the court has decided to give an opinion in relation to, again, Israel's legal position and legal rights without Israel acquiescing to such a process. That opinion was handed down in relation to Israel's security barrier. Notably, it didn't make any assessment of the reasons that Israel had erected that security barrier, naming the waves of suicide bombings that Israel was suffering, the civilian communities in Israel were suffering. Here, again, there's no mention of terrorism, no mention of the security situation that Israel has encountered in relation to Israel's conduct, both in Judea and Samaria and in the Gaza Strip. What would you say your assessment is, having set out in advance of this opinion being handed down, your perhaps concerns about the court's approach to fact-finding, and then looking at the majority opinion and what it has said about its approach to fact-finding?
Yeah, so I think exactly kind of how I predicted in my article before this opinion came out. The court gave quite a lot of importance to UN fact-finding commissions, commissions of inquiry, General Assembly resolutions. Actually, more to General Assembly resolutions than to the Security Council, which is an interesting point. I'm sure we'll have a chance to unpack it in a bit, but that was also quite an interesting way of getting away from the Security Council framework that, of course, has been part of the negotiations between Israel and the Palestinians about this issue. So kind of moving away from that. And so it gave a lot of importance to these types of sources. And as I wrote in my article, there's a problem in doing that because a lot of the sources relied on by UN fact-finding commissions, for example, aren't public, they're anonymous. There's no standard sort of uniform fact-finding process to any of these things. Also, I mean, the UN Security Council and the UN General Assembly, they don't have fact-finding powers themselves. So resolutions coming out of, well, particularly the General Assembly, because it makes decisions based on a simple majority, those are going to be very politically driven. And so if you give a lot of importance and value to facts underlying those types of opinions, not opinions, sorry, resolutions, and reports, knowing that those types of reports might actually not have gathered all the necessary facts in the situation, or the General Assembly resolutions might not really care about the facts because they might be politically driven. Well, that creates quite a bad, let's say, factual basis on which to draw legal conclusions. And so, as you rightly pointed out, the court made quite a lot of omissions. They did mention security concerns having been raised by Israel, but really just in passing, and also saying, we don't really care about those security concerns. We don't really believe in those security concerns. I think we'll get to that, but I mean, some of the clear kind of bits in the factual analysis that I wanted to highlight is, first of all, the choice of language. So, instead of, when discussing the history, instead of saying that Israel was attacked in 1948 and 1967, they used the kind of neutral armed conflict broke out. And of course, you might say that that's because they don't want to take a position on the kind of who attacked whom, and it's not really part of the process. But actually, it is very important because it would establish one of the factors as to whether or not the occupation is lawful or unlawful. So by using that neutral bit and not actually going into that, it already sets the scene for a kind of incomplete factual analysis. And then, one thing that really stuck out to me was the use of an increase in acts of violence to describe the Second Intifada. Um, so, I mean, just thinking about that for a moment, there's absolutely no reference to terrorist attacks having ever occurred in the historical analysis in this advisory opinion, and then referring to the Second Intifada as an increase in acts of violence. Again, very neutral. Where's the violence coming from? Why, what's happening here? No discussion on that. And then again, they mentioned the security barrier or wall, as the court refers to it, saying that it was a continuous plan since 1996, and then making no reference to it being related in any way to those increased acts of violence, as it were. So these kind of choices of language, I think, are quite important, and the court's decision not to engage with that factual analysis a bit more was quite disappointing.
I think in that context, it's also worth mentioning a matter which I found particularly surprising. And I have to say, given the context of everything we've discussed so far, I didn't expect to be surprised. But something I can only describe as a dishonest approach to the information that was before the court. Because while indicating it not going to go into any substantive fact-finding process, and it was essentially basing its opinion on the information that has been presented to it, the majority opinion, in fact, falsely states that it has not been provided with any information to substantiate Israel's claims to the territory. And this is despite there being substantial detail being put forward in several statements under Practice Direction 12. So these are statements made on behalf of international organisations. One was provided by UKLFI, also together with ELNet, thereby qualifying as such an organisation. And the reason that we know that these submissions must have been taken into account is that they are, to an extent, the arguments raised, the issues presented, taken into account by the dissent. To have suggested that there was simply no information before the court to make an assessment or to take into account rights that Israel has under international law that are impeded or impinged upon by their determinations is I found pretty shocking. Olivia, you've also, I think, talked in various articles about some of the omissions that are pretty striking in terms of the court's consideration of the issues. I don't know if there are any others that you wished to add to or draw to the audience's attention. We've discussed.
Well, sorry. I'll just jump in quickly because I did want to touch upon what you just said with
Yes.
the no information. The fact that the court said that it had seen no information, not only as to Israel's claims to the same territory, but actually its historical ties
That's
to
true.
the territory in question. And I actually think that is really striking because the territory in question, which we'll get to a bit later, also includes East Jerusalem. And so to say that the court has seen no information about Israel's historical ties to the old city of Jerusalem is it actually becomes quite comical when you think about it in that context. We'll go more into what the court said about the territories in question in a bit, I think, but that was just something I wanted to add because it is quite striking.
No, absolutely. Perhaps just before we come on to any additional omissions, then it's striking in terms of what you have said about the court's approach to the factual analysis, and also in relation to the 2004 advisory opinion that there was an assessment made by Justice Aaron Barak in an Israeli Supreme Court case, the Supreme Court sitting as the High Court of Justice, in Alfei Menashe, where Barak compared and contrasted the fact-finding approach, or at least the analysis being based upon actual facts found, in relation to the analysis conducted by the Supreme Court on the route of the security barrier and that provided by the International Court of Justice on its assessment of the security barrier. And that contrast was striking. I think it made the 2004 Wall opinion look somewhat ridiculous for the court not to have taken this contrast into account is pretty surprising, given that it formed a substantial part of the UKLFI submission. And it was essentially put forward as a warning to the court not to commit the same error once again, which was to draw conclusions on the basis of an incorrect factual basis. But coming back to the omissions, I know from our previous discussions, we've certainly touched on the absence of there being proper reference to the security threats that Israel faces. It's important, perhaps, that there was no consideration of the situation post the 7th of October. And I wondered what, if anything, you drew from the court's decision to cut matters off quite abruptly, given the current circumstances.
Yeah, yeah, exactly. So there's a paragraph in there. I can't remember the exact number, but the court decides that because the request from the General Assembly about this advisory opinion came prior to October 7, 2023, it's going to disregard anything after October 7, 2023. And well, it's interesting to discuss just the impact of that because the court, by doing that, didn't have to discuss the issue of Hamas at all. And Hamas is only mentioned, I think, in that paragraph. It's actually not mentioned at all. Its authority and the control it's exercised over Palestinians in the Gaza Strip since 2007 is not mentioned. And I think if the court would have included in the scope of the advisory opinion, excuse me, events after 7 October, it would have been forced to deal with the concept and existence of Hamas and the level of control they've exercised over Gaza for the past 20 years. And the fact that it didn't do that allowed the court to reach this conclusion later on that Gaza, even though it hasn't had Israeli control or presence, settlements, none of that since 2005, still formed part of the occupied Palestinian territory. And so by not having to discuss Hamas, they avoided getting into that conversation altogether and sort of made that very broad brushed conclusion. I wanted to mention one more point, which is relevant to this, but also to what you said right before regarding the kind of factual underpinnings of the Wall Advisory opinion as well. I mean, it's quite interesting that Judge Nolte, I think it was, in this advisory opinion, in his dissent, specifically said, by the way, this majority opinion, it's a legal characterization of the situation. It's not a legal determination because a legal determination would require a full factual investigation into Israel's various claims and legislation and specific incidents. And only then could we determine Israel's responsibility under international law and any consequences that flow from that. So this is just a bird's eye view of the situation. That's the specific words he used. And it's just well, it's just interesting to me because it really goes to show that they're quite mindful, the judges, that they really didn't have all the facts. And that if they did have all the facts, they would have probably reached or a different conclusion, like the Supreme Court in Israel did after the Wall Advisory opinion, when it really investigated all the relevant facts to the Wall.
It's perhaps striking that despite such an acknowledgement, Nolte did sign on to the majority opinion. All of the judges, with the exception of the vice president, did. And there has been some criticism already that the majority opinion is ambiguous and unclear. One can perhaps draw from that a sense that that ambiguity has been kept in place to enable as many of the judges as possible to sign on to the majority opinion. But one wonders if that does the cause of international justice any good, given that it may be in fact read in many different ways. Moving perhaps from the factual analysis onto the legal analysis, one of the most striking aspects, and I suppose it is a combination of the two, which means it's quite a nice segue, is the court's assessment of the territory and the status of the territory. Extremely broad brush. not invoking the legal frameworks which the dissent by Sebutinde applies. But it's striking that the court refers to the Palestinian territory as being contiguous, which rather suggests that it has sought to wipe Israel off of the map. Any reading of the West Bank and the Gaza Strip constituting contiguous territory would be, I think, very problematic in terms of cartography. But based on that and some of the other legal assessments, what do you make of what can only be described as an assessment as to the very essence of the status of the territory that it is being asked to opine on conduct based on that territory?
Yeah.
How did you read that particular, perhaps throwaway remark, but still a very significant one in the majority opinion?
I mean, I think the main well, one of the main concerns with that statement is that it also includes, as I said, East Jerusalem.
Mm.
And so it includes in its definition of occupied Palestinian territory the Gaza Strip, the West Bank, and East Jerusalem. And it's interesting because if you go back again to, historical facts, Jerusalem was not actually supposed to be a part of either state. It was supposed to be an international regime. And of course, that didn't happen because the plan of partition, didn't go through. But it's still very sort of concerning to me that the court just very quickly and easily decided that, well, this part of Jerusalem is occupied Palestinian territory. I don't really understand how it could reach such a conclusion. And then, of course, the problem with also calling the Gaza Strip part of um, occupied territory is, again, it ignores the facts from the past 20 years. And so, that's why I wrote this article about facts matter, because you can't sort of make legal findings on the basis of incorrect facts or incomplete facts. So I mean, that's my first kind of uh, to say my thoughts about that particular fleeting statement in the opinion.
And in relation to the occupation of the Gaza Strip, it occurs to me that the courts made this assessment on the basis that it suggests Israel exercises a large degree of control. In particular, it references Rafah, I believe, at paragraph 89. I mean, that plainly not only minimizes Egypt's responsibility in this context, but also seemingly invents a new test without anyone particularly noticing as to its establishment, supposedly of the qualifier of occupation in that case.
Yeah, exactly. I mean, I think so. It's been called this functional approach to occupation, where it's said, well, you don't actually need physical presence on the ground or boots on the ground, because if the occupying power still has the ability to exercise a sufficient amount of control over the territory, then it's considered occupied. And I was listening to a podcast a couple of weeks ago by EJIL Talk. They had invited Yuval Shani to the podcast to discuss this advisory opinion, and he said something really interesting in regard to this point. He said what the courts basically said, that the sort of elements of control that it references, control over the land boundaries, the maritime boundaries, kind of deciding what movement of goods, movement of people. Of course, it does that with Egypt in the Rafah crossing, which wasn't really mentioned. But in any event, that these types of elements of control that the court uses to decide that Gaza is still occupied, well, that makes the Gaza Strip quite indistinguishable from a siege under international law, because a siege has quite similar elements of control. And so the courts really kind of muddled up the law in that particular point, and it really hasn't made it very clear at all what it means. And it doesn't go into it very much. It's kind of it's not clear whether it means that Gaza is still occupied or whether it means that it's not occupied, but certain elements of occupation still apply. I mean, it's really quite unclear. And more interestingly, the court did seem to have done a big swerve, a 180 swerve from a previous finding in Congo versus Uganda in 2005, where it certainly did find that you needed boots on the ground and a physical presence for occupation to arise. So yeah, it's really quite interesting.
We'll come on to the questions in due course, but it's just caught my eye that the last question touches exactly on this point. The questioner writes, the ICRC years ago offered an opinion that the definition of occupation requires boots on the ground. Is that declaration still valid and is it still being used? I believe it was referenced by the ICRC. It's clearly also been referenced by the court, and it's been a prominent factor in much of the academic discourse on the issue of occupation in the context of effective control. But as you say, in this opinion, which is meant to assist with an understanding of established international law, and in fact, we're seeing a court almost invent brand new concepts of international law, which are entirely inconsistent, not only with its previous decisions, but also with a body like the International Committee of the Red Cross, charged with being a custodian of international humanitarian law, at least, which is pretty striking. So I just thought I'd raise that question, seeing as we were addressing the topic. Coming back, perhaps, just to tie all this up before we move on to the rest of the questions, Olivia, it's important perhaps to note that a number of warnings that were issued to the court about deciding to answer the questions that had been put by the General Assembly at all. And it's perhaps important to recognise that those questions were not of a normal nature. General Assembly Resolution 77247 that asked the court to opine essentially had already prejudged Israel as a violator of international law, perhaps for political reasons. And the 32 states that drafted and sponsored the resolution were asking about the legal consequences of Israel's violations. So essentially asking the court to take those violations as a given. In that context, what the court has delivered has been criticised as a flagrant violation of the Oslo Accords. It seems to have entirely thrown the Oslo process out of the window. Arguably, it breaches a commitment by both of the parties not to seek to change the legal status of the territory in any way outside of the context of that recognised bilateral negotiated framework. But the opinion itself also seems to ignore the internationally approved situation, the fact that these matters were laid down for final status through bilateral negotiations. And albeit that we're focusing primarily on the legal issues here, it's impossible to ignore, isn't it, the impact that this must have on any future for a negotiated solution if an agreement between Israel and the Palestinian Authority can be so unceremoniously torn up. So I wondered if you had any thoughts on the potential impact on the future peace process.
Yes. Well, the court says quite interestingly in the beginning of the advisory opinion that, we've had a lot of countries come and say that if we give an advisory opinion on this topic, then it might negatively affect the negotiations between the parties and the resulting peace process. But we can't really speculate on whether it would or wouldn't. So that's not a reason for us not to give the advisory opinion. But of course, it is quite clear that it would, particularly given what you've just said, with this kind of acknowledgement that the Oslo Accords are, let's say, irrelevant or cannot be relied on. What the court actually said about them is that you cannot use this bilateral treaty framework to justify or excuse violations of international law. But I find that quite a circular argument because, of course, it is the agreements themselves that set the scene for whether or not a violation has occurred. And so you it's very confusing to me because the court is saying you can't rely on this agreement to violate the Palestinians' right to self-determination. But it is the agreement itself that determines whether there's been a violation of the Palestinians' right to self-determination. And I think it was Judge Sebutinde who said this really well. She said, the Oslo Accords reflect the agreed bilateral framework through which Palestinian self-determination can be realized.
Yeah.
And this concept of self-determination is very broad, and it doesn't necessarily always result in a state. So there is an agreed process, and you have negotiations, and things will hopefully resolve themselves through this Oslo Accord framework. But the fact that the court is just saying you can't rely on it at all, and it has no relevance here because we've decided you've violated the law. I find that quite concerning, actually.
It strikes me that it's worth unpacking that concept of self-determination just for a moment for our audience, because it is a concept that has certainly gained significantly in stature and prominence and significance since perhaps its emergence after the World Wars. But it's right, as you say, that self-determination doesn't necessarily give you a right to a state. There is a well-known Canadian Supreme Court case, re the secession of Quebec, which is considered generally to have opined on issues that are matters of customary international law, so really general rules. And in that is the important qualifier that self-determination has to take into account territorial integrity and the sovereignty of states. If that were not the case, we'd have a great many more states. Every people would probably have a state. The Kurds would certainly have a state. But of course, that's not how international law works, because it recognizes the existence of established states and their territorial integrity. Here, and I would go so far as to say we've also seen this reflected in some of the jurisdictional questions and how they have been addressed at the International Criminal Court, the other court that sits in The Hague, that has jurisdiction over individuals, that we have seen similar, well, legal acrobatics, the invocation of this principle of self-determination in a way that I don't think, seen anywhere else to start to eradicate, in this case, Israel's territorial integrity. I don't know if you've seen similar discussions or issues in relation to self-determination that present a different set of applicable analysis.
Well, I've certainly seen in the ICC process a lot of the written kind of comments to the court's amicus brief call. Just by way of background, the court opened up for submissions from various international organizations and scholars and countries and states to opine on this idea whether or not the ICC has jurisdiction over crimes committed by Israelis in Gaza. And so, of course, the Oslo Accords have featured quite prominently in those submissions, and more so since the advisory opinion came out and said these are basically irrelevant. So, of course, I'm quite sure that we'll be seeing more such arguments by organizations and civil society that try and capitalize on that point.
Taking some more of those questions from the audience, then there are a number of them that reference the president of the court. And I'll take the liberty just of reading a couple out. One asks, what about the fact that the presiding judge is a Lebanese judge, a country that is at war with Israel, who has made umpteen, a technical term that, anti-Israel statements and is clearly biased. He should have recused himself, his presence and him presiding over a panel is in breach of every rule of jurisprudence. There are a number actually that have raised him in particular. What about the judges, anti-Israel bias, the Lebanese president in particular? Shouldn't he have recused himself? It's encouraging to see that there's already a general recognition of Judge Salam's track record, UN Watch has put out a great deal of information as to his previous statements as UN ambassador from Lebanon. And it is extraordinary, given the rules of the court, that he has not recused himself, and also that we hear reports that he has really been driving this process, the advisory opinion process, as well as the separate application that South Africa has brought against Israel alleging genocide, that he has been driving both of those proceedings through at some speed and prioritizing them perhaps um, um, over and above other cases on the court's list. Um, in relation to him and some of the other judges, what has your impression been, perhaps looking at also the separate opinions as to whether or not there's perhaps an element of disagreement in the preconceived positions that the judges are bringing in relation to Israel to their considerations of this matter?
Yeah. Well, I mean, certainly, I think there's been some pretty concerning reports about his past as an ambassador for Lebanon to the UN. I think it was an ambassador where he voted against Israel something like 210 times, and other such reports. And there is a history in the court of judges recusing themselves, and I think it was Judge Rosalind Higgins, who a few years ago recused herself from another case. I think it was the genocide case involving Bosnia and Serbia. And she recused herself because she had been a prior member of the UN Human Rights Council, where this matter had come up quite a lot, the topic. And so, because she felt that she had been involved in that process at the UN, she voluntarily recused herself. And I think there's something like 36 or 35 other instances of judges recusing themselves for similar situations. So it is, I suppose, voluntary, but it should really be done. And I think a lot of judges have acknowledged that, and that's why they voluntarily recuse themselves. And so I think it's quite concerning, and yeah, quite concerning is a good word for this.
Understatement.
Why the president has not done so. He certainly should have.
Well, diplomatically put, Olivia, I'm very grateful for that. Um, in terms of the other questions, one thanks us for mounting this webinar and asks, apart from the content of the opinions, I'm interested to know whether there are any similar rules governing the involvement of particular named judges as apply in England and Wales. Forgive me, this is also again about the recusement, and we've encapsulated that already. It is expected, and I forget the specific rule now of the International Court of Justice rules, that where you have, I'm gonna look it up and come back to that while we move to the next question, if I may, which I'm going to read out from here. If the Israel West Bank, Israel Gaza security barriers are advised to be illegal, what happens to the Egypt Gaza barrier and the Jordan West Bank border? Are these illegal as well? I don't know if there's anything that you want to add to the discussion that we've already had in terms of the assessment, the court's assessment of the legal status of
Sure.
the territory.
Um, I mean, I don't think it's the actual concept of a border per se that the court found to be illegal in the Wall advisory opinion. In that opinion, it decided that it was the route of the wall, the border, that posed problems because it wasn't west of the 1967 borders, so it actually infringed upon parts of the West Bank beyond that border. And it's really interesting actually to compare the judgment then of the ICJ with the subsequent Supreme Court judgment in Israel, because the ICJ, it sort of said, well, here's our understanding. The wall goes on parts of these lands, and therefore the wall is illegal. Whereas, of course, in the Supreme Court judgment, they did quite more of an investigation, and they compared, importantly, the security considerations of Israel for choosing that specific route with the impact that that specific route had on the resulting Palestinian residents in that area. And they found that in some cases, the Israel should have maybe chosen a slightly different route, but in other cases it was justified. And so that's a much more balanced opinion that actually splits up the wall in sections and looks at it from, section by section, whereas the ICJ then was criticized for not doing that and therefore came to a arguably broad brushed and possibly not correct conclusion.
And in relation to the court's rules, it might be helpful to reference Article 24, which references a solemn declaration that the judges are intended to make, indicating that they will act with good conscience. I'm pretty sure there's an additional one that references any previous conduct that they have had, essentially in advocating for a particular side. It was that one in particular which had jumped out to me, albeit that it is related, I'm sure, in normal circumstances, to having argued a case, given the track record that we have talked about, including calling Israel a terrorists, accusing them of war crimes, plainly prejudging many of the issues that the court has been asked to determine. Certainly those rules there would be a strong argument for recusal on that basis. Olivia, I'm going to take a few more questions. We're asked, given the contested areas are under Israeli sovereignty, in the binding international treaties of San Remo, the Mandate for Palestine, the Franco-British Boundary Convention, underpinned by Article 80 of the UN's own Charter, Article 71b of the Vienna Convention on Treaties, and the principle of uti possidetis juris. This is an informed viewer. Shouldn't the rulings of the politicized kangaroo court be dismissed for what they are, arguing Israel's case on the basis of security weakens her case? So this is interesting in terms of contrasting the legal arguments that are exemplified. I believe the dissent incorporated most, if not all, of those important legal instruments, as opposed to the realities of the situation, which, if one follows through what the court has suggested, that Israel must rapidly leave these areas, essentially ethnically cleanse the disputed territories of its Jews, what the security considerations would be. This is more of a statement than a question. Sorry, I'm reading them out as we're going. But would you have anything in particular to add perhaps to that statement? Other than our collective disappointment that the court has decided to approach these issues in that fashion.
I mean, I think there's an element of taking these types of opinions, looking at the kind of realistic perception. We were talking a little bit about this earlier. How is an opinion like this likely to be perceived, and what sort of consequences are likely to come from this? And of course, those who are quite interested in boycotting Israel and sanctioning Israel and so on will argue that obligation flows out of the advisory opinion, whereas others, myself included, would say it certainly doesn't. So there's an element of kind of looking at this from a practical perspective. If it is perceived by a majority of states that the court has come to really quite absurd conclusions, and that they haven't been based on appropriate investigations of facts, then that is what's going to be the result of that advisory opinion. It's not going to be acted on. And I think that the court has done itself a disservice here, actually, because in some of its historical cases, it's given this perception of being a very high authority and of coming up with very good kind of developments of international law and understandings of what it means, different rules and different perceptions. And I think that when it chooses to respond to these types of advisory opinions without doing the necessary factual investigation, and specifically acknowledging that it doesn't have to, it's not required to, it has enough facts to look at, and just making these broad brush conclusions. I mean, it really does lead to, as we see from these questions, lead to a lot of people not trusting the court anymore. And I think that's I mean, I think it's a shame, really, as an international lawyer. I think that's a shame.
Olivia, one of the issues we've not touched on yet is the allegation of apartheid, and there have been those commentators who have suggested that the court, in its majority opinion, essentially found Israel to be practicing apartheid. The majority opinion does reference a violation of Article 3 of the CERD, which includes both racial discrimination and apartheid. But of course, there are several judges, Nolte, Iwasanla, Sebutinde, that explicitly say in separate opinions that the facts are not there to prove apartheid. Do you have any conclusion on what I might call a fudge in the majority opinion, some sort of split between the judges, and how it was that this issue, this supposed violation of Article 3, was dealt with by the majority?
Well, I think it's really interesting how this was dealt with because the court said that there's been a violation of Article 3 of the Convention on the Elimination of Racial Discrimination. And of course, Article 3 mentions apartheid or racial segregation. So the court left that open as to whether it meant that Israel has violated this provision because it is practicing apartheid, or whether it has violated this provision because it is practicing racial segregation. And those two are two different concepts in international law and require different things. And it's just so interesting to me because you have judges, several judges that, voted for the majority opinion that have interpreted this completely differently. You have two judges, the president, President Salam, and Judge Tladi, the South African judge, who interpreted this to mean that the court found that there was a violation of Article 3 because Israel is practicing apartheid. And you have some other judges. I think it was Judge Iwasawa and Judge Nolte, Sebutinde, obviously, but she voted against the whole opinion. Said this is not apartheid. Actually, there's not enough fact, there's not enough evidence to prove apartheid, and that's a very important point because actually, what's crucial in determining apartheid is that there is a specific intention to segregate because of race. So here is where these security considerations would actually be quite important, because if there's a restriction on freedom of movement for reasons other than race, then those restrictions would not constitute a violation of the rule against apartheid. And I think it's really interesting here that the court has, again, completely disregarded the fact that the same Palestinian Arabs who live in Israel proper are not subject to any such restrictions. They have equal treatment in the domestic law and policy of Israel. And so it would be quite odd to come to the conclusion that Israel is segregating or practicing apartheid because of race in one area, when that same race in another area would not be subject to the same restrictions or apartheid. It's just quite illogical. So I think the motivation there of various restrictions are very important. And again, it's disappointing that the court didn't discuss them.
On that, I'd suggest it also ultimately comes down to a proper consideration of the status of the territory. And when we consider, with Hamas's self-governance of the Gaza Strip, with the Palestinians enjoying an autonomy in areas A and B of the West Bank, and also having self-governance, any comparison of those individuals with Arab Israelis who live as citizens of Israel is misguided, perhaps to say the least. One questioner, Olivia, asks, can the UN and the ICC be held to account in any way for their prejudiced opinions and anti-Israel bias? Now, of course, international institutions, UN bodies, have immunity, and we are, in relation to the ICJ, of course, dealing with the UN's highest court. My suggestion would be that it's discussions like this, it's rigorous intellectual criticism of the approaches that the court has been taking that are the best way of holding the decisions that these judges make, or the opinion in this case, to proper account. But do you have any additional thoughts on holding these decision makers and the processes themselves to account?
Well, I think you've touched upon, or the person who asked this question has touched upon an issue with international law generally, which is you have international law, but you don't have an international police. You don't have an international government that can hold people and states, well, people, yes, that can hold states accountable, and international organizations, I suppose, that breach these types of um, um, neutrality, not obligations, you know what word I'm looking for, accountable. And so it's an issue generally with international law. And it comes up here again today. It's very difficult. I think it would have to be through political discussions like we're having today, but also probably on the global scale. Countries ultimately determine, like I said, the perceived kind of authority of advisory opinions. And as we've said time and time again here today, if it's not perceived that the findings were just, then probably they will not be acted upon, and that's really where we are.
I might just add that it's the assessment, both of the legal analysis, and we've talked about some of the ways in which it has really been stretched or inverted here, but also the practical consequences of what is being called for. I mentioned essentially the ethnic cleansing of Jews. The court specifically called for the evacuation of settlers. That very much appears to me to condone ethnic cleansing. And when we're faced with the highest court at the United Nations that is calling for that sort of consequence, I would at least hope, as you say, that states, considering the political ramifications of something such as that, would treat it with some degree of circumspection. The last question that I want to introduce is about where we go from here. So one asks, what do you anticipate happening now, given this advisory opinion? And it's important, and we considered the timing of when we were going to bring this webinar together, because there was a flurry of discussion when the advisory opinion was originally handed down. But we are having this discussion closer to the UN General Assembly meeting next month in September in New York, because there's every expectation that if anything is going to happen on the back of this advisory opinion, it will be in the context of that general meeting. But what are your thoughts or predictions as to what the United Nations General Assembly might be doing, having requested this opinion, now that it has received it?
Yeah, I think that it's quite likely that the UN General Assembly will vote to approve and accept all the recommendations of the International Court of Justice. And I don't think there will be any major debate or discussion, unfortunately, about the incomplete and erroneous factual basis on which it was issued, and the kind of unclear and questionable legal conclusions in some of these issues. I think that's just reality, unfortunately. I think there's going to be quite a lot of civil society seeking to lobby for this as well, lobbying their governments and so on to accept and vote for the General Assembly resolution that is going to come out from the September meeting. So again, as you've been saying, I think it's equally important to have these discussions about the problems with accepting an opinion like this. But again, just looking at the experience from the Wall advisory opinion, the General Assembly did vote after that opinion to approve and accept all of the recommendations of the International Court of Justice. And nevertheless, nothing was really done about it in practice. So I think that is really just states signaling that they don't really think this is quite right. And you can contrast that to other advisory opinions that very much were taken seriously. The Chagos advisory opinion, the General Assembly set out a time frame from which the UK should withdraw from Chagos, and the UK did, and it was kind of very straightforward. But there, that situation was very different. It wasn't as convoluted and complex as this. And I think the main problem here is that the court has tried to fit this situation into a pre kind of determined mold of occupation and annexation, which countries do to other countries. And that is just not the factual situation on the ground. So that's what distinguishes this situation from previous ones.
And when you say that not very much happened off of the General Assembly's endorsement of the 2004 Wall opinion, it's probably worth just clarifying for our audience that, of course, General Assembly resolutions are not legally binding either. They are political resolutions. It would only be a Security Council resolution passed under Chapter 7 of the UN Charter, the strongest legal tool, legislative tool, if you will, in the UN's legislative box. Only a Chapter 7 Security Council resolution would be considered to be legally binding. And of course, those are understandably extremely rare. In this context, and given the extraordinary leaps that the court has made, I'd consider there to be every expectation that the United States would prevent any resolution of that nature with legal consequences from being passed. But nonetheless, the consequences of the court having taken this particular approach are significant. Mostly, again, my view here, for the credibility of that institution. And everything that we have discussed today, I think, bodes pretty badly for the International Court of Justice itself and for these issues in international law more broadly. We see the politicization of these important questions potentially leading to further loss of credibility for international law more generally. But Olivia, it's been a real privilege to be able to engage in this discussion with you. I can see lots of thanks and support already from the audience. I'm sorry we didn't get on to absolutely all of the questions, but undoubtedly, especially when this matter comes up for consideration by the UN General Assembly, there'll be a lot more to say. There'll be briefings coming out from UK Lawyers for Israel, articles circulated, and we will ensure that some of the pertinent articles that we have referenced in our discussion are sent out to our audience members when the recording of this webinar is circulated. Thank you so much for joining me.
Thank you so much for having me.